There were several things about Jacqie Spradling's disciplinary hearing that I found troubling last week. And I'm going to try to be as brief as I can as I detail my observations. One is that Shawnee County Deputy District Attorney Charles Kitt made a statement during his testimony that Dana Chandler was the person responsible for slashing Karen's convertible top, when in fact 8 years ago, before the first trial, they had attempted to introduce that evidence, and Judge Parrish issued a written ruling stating that that could not be allowed in because the convertible had in fact been parked at a sports bar the entire night. And so the vandalism that occurred to that vehicle could have been committed by anybody, and it was certainly never established to have been committed by Dana. And yet here we are 8 years after Dana Chandler was convicted of a double homicide by a prosecutor who we now know introduced evidence that was false, manufactured, embellished, based on theories rather than proven fact. Okay, here we are 8 years later, and we still have the new batch of prosecutors under the new district attorney, Michael K. Gay, still saying things about Dana Chandler that are categorically unproven. So that was troubling to me. Another revelation that came through former lead detective in the 9-year cold case, which resulted in Dana Chandler's conviction, Sergeant Richard Voley. Sergeant Voley admitted under oath to the panel that he had in fact researched whether or not there was a protection from abuse order filed against Dana Chandler during the divorce. And he said there was no evidence of that, that the people at Douglas County Court could not produce any protection from abuse order. And when I believe it was panel member Darcy Williamson asked him at the end of his testimony whether he informed Jacqie Spradling of that fact, he stated that he had. Of course, this begs the question, why did Jacqie Spradling question Sergeant Voley about a protection from abuse order during Dana Chandler's 2012 trial? Why did she ask him to tell the jury what a protection from abuse order was, to explain it to them in detail? And why did she ask him whether Mike ever obtained one against Dana Chandler? And why did Sergeant Voley reply that he indeed had obtained a PFA against Dana Chandler in 1998? And when asked by Jacqie Spradling, did Michael Cisco obtain a PFA against anybody other than the defendant, he turned to the jury, looked them right in the eye, and said, nobody else. And on cross-examination, when Dana Chandler's attorney, Mark Bennett, asked him whether he had that, well, he asked him if he testified that there was one, and he confirmed that there was. He said, that's correct. And then he said, do you have it? And Sergeant Voley's answer was, it's in the divorce file. But when Jacqie Spradling was questioned about it by the justices of the Kansas Supreme Court, she finally had to admit, after prefacing her comments with, quote, I don't want to mislead this court, after she already misled a jury, after she already put it in writing in a brief that there was a protection from abuse order, she finally caves and says, I don't want to mislead this court. There is no protection from abuse order or protective order in the divorce file. Indeed, the only order Michael Cisco ever obtained in the divorce was a mutual restraining order that is given out as a routine matter at the beginning of a divorce. And it was for both people. So nothing that even resembles what Jacqie Spradling told the jury ever existed. Mike never went to a judge and said, save me from this woman, Your Honor. And a judge never agreed that he needed protection from Dana Chandler, that she was a threat to his personal safety, that she was a dangerous person. That never happened. And she certainly can't violate an order that never existed. So Jacqie Spradling went to great lengths to win that conviction and get the praises of the victims' families who believed they knew who killed their loved ones. But she did it by violating her oath and every rule of conduct because there was no actual evidence. If they had any real evidence that connected Dana Chandler to the murders, they would have used that. And to make matters worse, she filled the courtroom with packages of stuff that gave the illusion of evidence against Dana Chandler. The exhibits numbered over 1,000, and that was presumably very persuasive to a jury who had to decide in a circumstantial case whether this person on trial was responsible for the murders of these two victims. We all want justice for the Cisco and Harkness families, but it's not justice to convict the wrong person by lying or manufacturing evidence. Not a single exhibit entered by the state had any connection between Dana Chandler and the murders of Michael and Karen. Other than that, these were items collected at various scenes. Karen's home, Mike's home, and Dana's home. Shorts, shirts, shoes, power cords, mail, pictures. Over 400 pictures, each one given a separate exhibit number, so that we can lead the jury to believe there was over 1,000 exhibits of evidence when all it was stuff, none of which proved that Dana Chandler committed the murders. This entire prosecution of Dana Chandler is a smoke and mirrors travesty. That's not how we convict people. We don't convict with illusions and trickery and sleight of hand, shell games, where you can't keep up with what you said, but you got a clear impression that the trigger for the murders was the 5-minute phone call when Jacqie told the jury that during that call, Mike told Dana he was getting married. And they stored that away in their bank of information to see whether there was enough here to convict. And so they manufactured a motive. They literally manufactured a motive, because even Charles Kidd himself acknowledged there was no evidence about the content of that phone call. And yet, let me move on to another witness during last week's hearing. Former KBI agent Mark Malik, who seems very proud of his illustrious career and states that he's never been investigated or sanctioned. And yet we found some document that he took a self-demotion at one time. And I know for a fact someone filed a complaint alleging that he had an improper relationship with County Attorney Shauna Miller. And Shauna Miller was on stand last week as well and denied any relationship between the two of them. So he made statements that were questionable as well. But during his testimony, he maintained that he interviewed Dana's sister Shirley a couple weeks before Dana was arrested, and that although she was a reluctant, witness or reluctant to speak to them, he, because of his training and expertise and interrogations, he stated that he was able to, quote, extract from Shirley Regal the information that in fact Dana did find out about Mike and Karen's engagement exactly 2 days before they were murdered while asleep in their bed. But thankfully we had Deputy Disciplinary Matt Vogelsberg, who was ready to cross-examine him and to remind him that there's a transcript of that interview. So he asked him again whether or not that was the time frame that Shirley stated Dana found out about Mike and Karen's marriage. And Mr. Malik quickly adjusted his previous statement. Very troubling. Very troubling. And then we have the judge who presided over the Dana Chandler trial, Judge Nancy Parrish. I was stunned that she became a witness in this proceeding. And I would describe it as a character witness. That's my personal observation and opinion. She stated right at the beginning of her testimony that it was her understanding that under the Judicial Code of Conduct that she would not be able to be a character witness unless she was subpoenaed. Apparently they wanted her to sign an affidavit stating that she wouldn't have been misled if Jacqie Spradling called a mutual restraining order, a protection from abuse order, or a request for a restraining order, turned it into an order that was granted, even though it was only a request. I mean, it's just stunning that she would attempt to provide cover for a prosecutor who is alleged to have committed so much gross and flagrant misconduct during the trial that she presided over. It's perhaps some self-protectionism going on there, where she's defending her handling of the trial as much as she's trying to provide a defense for Jacqie Spradling, or at least provide testimony. But it was her understanding that she could apparently be a character witness if she was subpoenaed. Now, it's interesting to note that recently Dana Chandler has subpoenaed Judge Parrish in her pro se representation in her retrial, and Judge Parrish has filed a motion to quash, meaning that she's objecting to being called as a witness in Dana Chandler's trial. There's obviously, Dana Chandler has some reason to subpoena Judge Parrish and wants to ask her certain questions, but Judge Parrish is fighting that subpoena. However, as far as I know, she didn't object to being subpoenaed to appear in Jacqie Spradling's disciplinary hearing. But during that testimony, she was asked about her order to both attorneys, Mark Bennett and Jacqie Spradling, during the trial. She specifically stated that she did not want any references to anybody in the gallery. Apparently, in a different case, Jacqie Spradling had motioned to people in the gallery to stand up at a particular, predetermined time for effect, and Judge Parrish said, "I know you know what I'm talking about," and Jacqie Spradling said, "Yes, Your Honor, I understand your parameters." And then Judge Parrish was even more specific in her admonition to both attorneys. She said that emotions are running high on both sides, and she said, "I don't want that to happen in this case, and I don't want references to folks here at all." So what does Jacqie Spradling do? She plays a tape of a phone call between Dana Chandler and her sister Shirley Regal, and then she looks over at Shirley in the gallery and says to the jury, "There she is, Shirley Regal, her good friend, the one giving me the look." Judge Parrish, during her admonition to both attorneys during a bench conference, stated that she would, quote, "be jumping all over you if you do that." But yet Jacqie Spradling did the very thing she told her not to do, and she did not jump all over her. However, Mark Bennett did jump up and ask for a bench conference and requested a mistrial due to Jacqie Spradling pointing to Dana's sister in the audience. Well, last week during the disciplinary hearing, I was shocked to hear Judge Parrish say that she didn't think it was that damaging or that important, because she stated that no one knew who Shirley Regal was, as she didn't testify at the trial. Well, first of all, they knew she was, because they had just played a snippet of a conversation between Shirley and Dana. And second of all, Shirley Regal did testify at the trial. So Judge Parrish also made a misstatement of fact